Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
From St. Louis Public Radio, this is St. Louis on the Air. I'm Sarah Fensky.
The lights were timed not for maximum safety, but for maximum revenue generation.
That they have actually changed the timing of how long the yellow is.
And that was the problem with the other red lights. They didn't have to catch the face.
This should not be a money-making proposition for the city of St. Louis. It should be a safety issue.
Perhaps the biggest story in St. Louis in recent weeks has involved the community radio station KDHX.
I'm here to state that this meeting is not a validly called meeting of the corporation.
Unless the membership or donors or whatever can show that the board is not operating in alignment with the mission of the organization, at which point, again, we're talking about a lawsuit to challenge their right and how they're operating the company.
A St. Louis jury returned a $745 million verdict against the company that manufactures Whippets. How did the verdict grow so big? And do the grieving parents have any chance of collecting? And Missouri's lawsuit accusing the Biden administration of coercing social media companies to censor citizens notched a victory this month at the 5th District Court of Appeals. What could happen next? And it's also KSDK versus KMOV on one of the biggest issues of our day. Who owns the phrase first alert weather? Yes, it's our legal roundtable, and we're not afraid of confronting the big questions. And joining me now to help us do just that is Eric Banks. He is an attorney and mediator at Banks Law. Eric, welcome.
Thank you.
And we're also joined today by Brenda Talent. She's a longtime attorney and previously a partner at the firm now known as Bryan Cave Leighton Paisner. Today, she's the CEO of the Show Me Institute, which advocates for small government and market solutions for public policy in Missouri. Brenda, welcome back.
Thank you for having me.
And last but not least, we're joined by one of the OGs of this roundtable. That is Bill Freivogel. He's an attorney and a professor of journalism at Southern Illinois University, Carbondale. Bill, welcome.
Hi.
So I promised some big issues, that giant Whippet verdict and Missouri's lawsuit against the Biden administration among them. But first, there's something a lot of people are talking about in St. Louis, and I get the sense that very few of them have any idea what they're talking about. And I'm talking about red light cameras. The St. Louis Board of Aldermen wants to bring them back, and there's some big questions about whether they'll hold up to court scrutiny. Eric Banks, you have some thoughts on this. Are red light cameras good or bad?
Red light cameras are very good, and the voice of the community agrees with me. I had a conversation with one of my friends on Saturday, and I basically approached this issue with her. And this lady is a real junkie. Not the kind you think. I mean, she's a news junkie. In general, a political news junkie in particular. She lives by KWMU, Channel 9, CNBC, CNN. She just follows everything. But that does not translate into political contributions. Go figure. She does not give political contributions. She said that if Mayor Jones pulls this one off, she'll become a political contributor of hers.
Wow.
That's how deep this issue runs.
She really cares about this issue. I think a lot of city residents are fed up, the traffic violence in our streets. I'm constantly worried that somebody's going to run right through.
And the people who work in the city.
Yeah, that's a good point. You don't have to live here to be affected by this. So, okay, there's a groundswell that now thinks this is a good idea. Brenda, we had red light cameras in Missouri years ago, and the Missouri Supreme Court said, you can't do this. So can we do this?
You can do it, but you better dot your I's and cross your T's. I mean, the key here is the devil's in the details, right? The city has proposed an ordinance, which is fairly detailed. What the Missouri Supreme Court said is before you charge people, you actually can't shift the burden of proof. So, in other words, city, if you're going to issue a ticket for speeding through a red light, you're going to be able to identify who did it and show, in fact, that they violated the law. So the city is talking about installing cameras where they catch the person's face, because they're going to have to prove that the person they say was driving the car in order to meet their burden of proof. And that was the problem with the other red lights. They didn't have to catch the face. They just took a shot of the vehicle license tag. And because of that, they would say, the owner of the vehicle, you're the one at fault. And you can't do that. You can't change that burden of proof.
And is that a Missouri Supreme Court thing, or that's the law of the land?
That's the law due process. I mean, they're issuing a ticket for violating the law.
Yeah.
Now, one can say, again, the devil's in the details. Are we going to go back to wearing masks or other things that obscure your vision when they take these photo shots? I mean, it's probably going to be pretty sophisticated equipment that they're going to need.
You know, I'm thinking of a lot of times the people I see tearing past the stop sign near my house. These are people who have stolen cars, and they have run amok, and there's no way that this car is going to be able to be traceable to the person who's actually doing the red light running. Does that mean then, Bill Freivogel, this person can't get ticketed?
Well, I think this is a way to try to catch that person.
Yeah.
And you know, as long as, I mean, I read the statute, and I think they've done a careful job of trying to answer the due process questions that the Missouri Supreme Court had raised. By the way, this case, I look back and I found some 2013 legal roundtable notes where we were talking about red light cameras. So
you are such an archivist.
It's just a Google search, but a Gmail search. Anyway, I think they've done a careful job of trying to make sure that there is due process, and on how the person's identity is verified. They've got safeguards about how the photos will not be used for facial recognition, artificial intelligence, and stuff like that. So they're addressing privacy concerns. They're not trying to make a lot of money on this. They're going to use the money for road infrastructure to make safer roads and driver's ed and that sort of thing. So I think they've done a pretty good job from what I can read in the statute.
So Beavis Schock, who is one of the few libertarians left in Missouri, he was responsible for getting this struck down at the Missouri Supreme Court last time. Brenda, I know you like Beavis, but it sounds like he's going to have a harder time this time if they go ahead with this ordinance the way it's proposed.
If it's carefully implemented and you're observing due process rights. I mean, I can envision cases where they might say, oh, we've identified this person, we've issued the ticket to it, and then you're going to get into a controversy over whether they've adequately identified the individual or not, or there could be close cases on whether the law was violated or not. I mean, whenever you're dealing with technology, that can arise. But as Bill said, the ordinance is carefully drafted to protect the due process rights.
So if you have questions about how this red light camera ordinance could possibly end up being constitutional, we do have some experts here today. One who remembers discussing it all those years ago and has read his notes. Our phone lines are open, 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air. Eric Banks, you mentioned this idea of broken windows, that this is the sort of thing that people feel like you have to go after red light running.
I agree. Yes, it's running the risk of sounding melodramatic. It will lead to the downfall of society as we know it. It's like a domino. And if you have people running red lights with impunity, realizing nothing is going to happen to them, where are they going to stop? And also, I'll say that we need more police officers in the city of St. Louis.
I would agree with that.
Well, that might be a 2-to-1 vote of our roundtable today. But this being a legal roundtable and not a political one, I'm going to change the subject here. There's another big issue being talked about in the city of St. Louis. This involves the Jail Oversight Board. They've ended up in opposition to Mayor Tashara Jones, even though she created the board, she appointed them to it. Now they have fought for the right to hire their own lawyer, not just to rely on the city councilor's office. There's an aldermanic bill that would allow the Oversight Board to do just that. But under the compromise that came into this bill, the firm would come from a list pre-selected by the city councilor. The city councilor and the oversight board aren't necessarily on the same page. They could end up being adverse parties. Eric, you're a former city councilor. Do you think there's a problem here if they have to hire off the city councilors list?
It's not an insurmountable problem. When I was the city councilor, I had one attorney representing the comptroller's office and one attorney representing the city of St. Louis, and the comptroller's office and the mayor's office were in loggerheads. So we had one attorney defending a city agency, another attorney representing technically the whole city.
Yeah.
So an ethical wall was set up, but those kind of issues occur all the time.
Okay. This is something lawyers are used to sort of sorting out. Bill, would you agree with that?
Well, I mean, I think it's too bad that the city councilor gets to give the list of possible people to appoint for this independent lawyer, but it sounds like it was a compromise that was necessary. I mean, I think the current city councilor, some of her cases that she's appealed have been, while protective of the city, have not been in line with the kinds of political statements that some of the city officials, including the mayor, have made. So, putting this, giving her the right to, pick the list from which the person's chosen, I think it's unfortunate, but probably better than not having a mostly independent lawyer.
I should say that the Reverend Darrell Gray, who is a member of that oversight board, he is very upset about that provision still. So I think, some members might feel like there's a compromise. There's still a lot of members of that board who aren't happy about it. It'll be interesting to see. Brenda, do you have any thoughts on whether this is a complication for this oversight board to have somebody where they're somewhat dependent on wanting to get, stay in the good graces of the city councilor?
It's a bit of a difficult spot to be in. But look, whatever lawyer they select is going to have a duty of representing them, not representing the city. So they're supposed to pursue the best interests of the oversight board. And if a lawyer's not doing that, well, there's another issue which the board can complain about and the lawyer will be held accountable for.
I want to go to the phone lines. We were talking about red light cameras just a minute ago. Bill is calling from Creve Coeur, and he has a question about red light cameras. Bill, hi, you're on St. Louis on the Air.
Hi, thanks for taking my question. My question is that my understanding at some point that one of the issues with these cameras had to do with the timing of the lights, and that in some instances the lights were timed not for maximum safety but for maximum revenue generation. And I'm wondering if in this ordinance anybody has addressed mandating that the lights are timed for safety rather than generating revenue.
Bill, thank you so much for that. I know that has been an issue with some of these red light camera companies, that they have actually changed the timing of how long the yellow is so they can catch more people trying to blast through the red. And it has actually led to very serious injuries because it makes it much harder for drivers to stop in an effective way. It looks like, Brenda, you and Bill both looked at this ordinance. Did you see anything about that addressed specifically in what you saw?
I was focusing more on the rights of the individual who received the ticket. Bill, I know there were a lot of provisions relating to who they would hire and what that company could or couldn't do, but I don't recall specifically that issue.
Yeah, I mean, I did. There are portions of this ordinance that say, you can't give a red light ticket to somebody who's turning right on a red, and there are provisions in there that talk about the amount of time that is recorded before the intersection and after the intersection. I don't know whether that timing requirement handles the issue that the caller's calling about or not.
That's something I think the Board of Aldermen will want to be paying attention to as they, if they proceed with this and go out and get a vendor. Can they make sure that vendor's not trying to take shortcuts to just maximize their revenue?
Yeah, it's a valid question. This should not be a money-making proposition for the city of St. Louis. It should be a safety issue.
Bill, I want to bring this back to you for a moment. You mentioned City Councilor Sheena Hamilton because we were talking about some of the positions she's taken on appealing some things that maybe aren't in line with the publicly stated values of the administration that she works for. There was another case along these lines that actually was at the appeals court just last week. This involves a lawsuit over former Aldermanic President Lewis Reed and his use of his Twitter account. Now, he is in prison, even as we speak here today. What's going on with this appeal?
Well, it's interesting because his successor, Green, says she doesn't want to pursue this case, but Hamilton, the city councilor, I think, believes that she still can pursue it, whether or not Green wants her to. I mean, this is a big issue here in St. Louis and nationally. Whether or not a public official who gets criticized on a public-facing social media account can cut off their critics, annoying citizens expressing their opinion.
And just block those citizens. And if you block someone on Twitter, they then cannot see what you tweet.
Right. And I believe in this case that Reed's position, Reed, who had cut off a citizen, lost in the court, and that Hamilton wants to appeal. There happens in November, the U.S. Supreme Court is taking up two cases that are these very facts, one from California, one from Michigan, where public officials who had social media accounts cut off annoying citizens who commented on them. In the California case, the citizens won, and saying that the public official was violating the First Amendment by cutting off citizens based upon what they had to say, the content of what they had to say, discriminating against the content of what they said. In the Michigan case, it went the other direction, and the public official was upheld. So we'll find out in November how that plays out. Seems like the Reed case will be just whatever the Supreme Court decides. In that November case will apply.
It could render this all a moot point.
Yeah.
So is this what we want to be spending our tax dollars on?
Yeah, well, maybe not.
The damages were only $1.
It does seem like an odd one to appeal. I think we've questioned some of the stances taken by City Councilor Sheena Hamilton before, but she does have a fiduciary duty to the city, even if it doesn't line up necessarily with what progressives want. This is not one that could really cost the city much money. Does that strike you as weird that she's choosing to spend resources in appealing this?
I found it weird just because I thought the overall, when you look at the factual record, to me it seemed pretty clear cut that he was using his Twitter account for official business, and that the city was linking to it and allowing people to go onto it. So they were promoting it also.
Eric, you're the former city councilor. I got to give you the last word on this topic. Would you appeal this case if you had the president of the Board of Aldermen is saying, I'm fine if we don't appeal?
Yes, I would. Yeah. It's a bigger issue at stake, and I think that the final arbiter of whether or not a lawsuit should be filed by the city or defended by the city should come from the city councilor. And the mayor's option, if she's ever dissatisfied with the city councilor, is to call the city councilor in, have a conversation. I don't like the direction that your office is going. And then it's the city councilor's responsibility to offer her resignation. And usually people get on the middle ground, but that's the way the game of politics is played.
We do need to take a quick break, but when we come back, we're going to dig more into some First Amendment issues involving social media companies. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our legal roundtable. Now, Brenda, we've talked on this show previously about Missouri's lawsuit against the Biden administration. The suit alleges that federal officials coerced social media companies into censoring certain content. And Missouri said in its lawsuit that's a violation of the First Amendment. A Louisiana judge ruled for Missouri. The federal government then appealed to the Fifth Circuit. The Fifth Circuit has now made its ruling. This is a long ruling here. Is there a chance you can distill this for the layman into what they said?
I will try. So to have a First Amendment violation, you actually have to have what's called state action. So you have to have the government in some way coercing speech or suppressing speech. So we're dealing with these social media companies, which are private entities. So the first question is, well, if they decide to censor their users based upon their algorithms or whatever, that's not an issue. The issue comes about when the allegations and the factual record are indicating that our federal government got, if you will, really intertwined with these private entities. One could even argue coerce these private entities in ordering to change their algorithms or, again, offering benefits, if you will, for them assisting the federal government in suppressing certain kinds of speech. That's where you get into the allegation that there's a violation of the First Amendment. At the Fifth Circuit, at the lower district court, the injunction that court issued applied to a number of government entities. The Fifth Circuit came back and really pared that down to just a few, but they were saying that with those entities, and it would have been the White House, the CDC, the Surgeon General, the FBI, that there was, in fact, state action sufficient, or the facts supported the, if you will, the entanglement of these organizations to say they violated individuals' First Amendment rights. Now, the Fifth Circuit has issued a stay on their order because there's been a motion for rehearing by the panel or en banc. And so right now we're waiting to see what the Fifth Circuit does with that rehearing request.
Okay. And if if this thing goes into action, I'm sorry for the clumsiness of how I just said that, this would mean that these public officials are enjoined from being able to have these kind of contacts with social media companies?
I think it's the kinds of contacts they have. It's the kind of thing, if you would think about it, if, Mark Zuckerberg, if he were to be best buddies with President Biden and they were talking and President Biden said to him, some of these people on your accounts, they're just crazy. And then Zuckerberg thinks, oh, I can change my algorithm to get rid of them. And then he goes and does that. That's not what we're talking about. It's like these ongoing discussions where, okay, we're not really happy with your algorithm. You still have people on your system who are, putting down the vaccines. You need to do something about it. And when you look at the factual record, again, there is so much back and forth. It does begin to look like the government is dictating what the private companies are doing.
I will say, as much as I know many progressives who are upset about this decision that came out of the Fifth Circuit, it does bother me to think of the federal government going to social media companies and saying, I don't like what so-and-so is saying. Can you make sure fewer people see it? I don't want them to ever have that power to be able to silence their critics. Bill, do you think the Fifth Circuit makes a good decision in this case?
No. And I think, the lower court, I don't think there's coercion here. I think that we want to be able to have government officials who are experts, like the Surgeon General, like CDC, the FBI, to be able to talk to the social media companies where they are finding that, somebody's putting something out there about, bleach is really great for getting rid of COVID, or vaccines are going to cause autism. All of these or that some sort of like weapon caused the fire being developed caused the fire in Hawaii. I mean, these there's not just the rights of the individual poster to get his or her views out there. These social media operations, which as Brenda points out, are private entities. They have a First Amendment right and an ethical obligation to edit their platforms in a way that we hope will eliminate hate speech or incitement to riot.
If they're trying to do that, they've done a terrible job of
they may
those
not.
things.
They haven't succeeded, that's for sure. But they are trying. I mean, that is what they're trying to do.
But so if they did that on their own, if they weren't having contact with federal officials, they could do that.
They can do it even if they have contact with federal officials. In my book, I don't think this was compulsion. The way the Solicitor General refers to it is a back and forth in which the government and platforms often shared goals, worked together, sometimes disagreed, occasionally became frustrated with one another, etc. Even the Fifth Circuit didn't use the term coercion. They said a coordinated campaign orchestrated by federal officials that jeopardized a fundamental aspect of American life. That's the Fifth Circuit language. I just don't think that there is much evidence of coercion. And without coercion, there's no violation of the First Amendment because, as Brenda said, Congress shall make no law. It's only state action.
Well, it's not only coercion. It's like this, what I would call excessive entanglement, too. But I would just disagree with you on the factual record. When I read the facts as a citizen, I am really concerned about the back and forth they had about what the social media platforms were doing. And it almost sounded like the social media platforms became agents of the government in how they were acting. And, you know, when you have basically always the fear that someone's going to come after you, that too can chill First Amendment rights. I mean, I would argue the best remedy for this is to allow more voices, let the debate happen. So, all right, government, you have a problem with, you know, the crazy person in Montana saying what they're saying. Come on the social media platform and just inundate them with your rebuttal. That's what the First Amendment's about.
I agree with Brenda. And I don't think I have ever voiced opposition to a position of the Biden administration in public before, but I think he's as wrong as two left feet on this one.
So, Bill, this is likely going to the U.S. Supreme Court.
I think so.
I mean, it's signs indicate.
Yeah, I mean, the Biden administration has asked the U.S. Supreme Court to stay the Fifth Circuit ruling, and I think last Friday, Justice Alito, who handles that circuit, put in a temporary stay. It was supposed to expire yesterday evening, and I haven't seen where the Supreme Court has done anything. You know, Monday is the first day of the next term. It's in the realm of possibility they could agree to hear the case on Monday because, I mean, they could announce they will hear the case. They could announce that on Monday because the federal government has said, even though we haven't yet filed our petition for writ of certiorari, you can consider our application for a stay to be an application for a writ of certiorari. So that they could act that soon. And I think, you know, it'll be really interesting. It'll be closely divided what this court thinks. But I think this could be another one of those cases where the conservative majority on the court doesn't hold together, where you could have the Chief Justice pick off one of the other conservative justices and join with the Democrats.
Interesting. Well, if Eric Banks' vote is anything, they may lose a liberal justice on this. Who knows? This one could go either way. Speaking of the nation's highest court, the ACLU of Missouri is asking the U.S. Supreme Court to take up a First Amendment case involving protesters in St. Louis. Sarah Molina and Christina Vogel were legal observers at a police protest. They wore bright green hats that read National Lawyers Guild Legal Observer. After they were given orders to disperse and went to a home around the block, the St. Louis police threw canisters of tear gas at them. Now, they argued in a lawsuit this was retaliation for their speech, and the speech being the hats that suggested they were monitoring the cops. The Eighth Circuit dismissed their lawsuit against police officers alleging First Amendment retaliation, and this seems to all come down to clothes. What sort of protections do clothes have under the First Amendment? Bill, what can you tell us about this?
Well, it's an issue on which the federal appeals courts are divided. And the Eighth Circuit narrowly decided to join the ones who said that, you know, it's not words on clothes, if they're not really understood to be a particular message, are not necessarily protected by the First Amendment. There are about three other circuits that take a different view. This is another case that the Supreme Court could decide on Monday whether or not it will hear. I mean, when you have circuits divided like that, that's one of the things that the Supreme Court is looking for. So I think it's in the realm of possibility that the Supreme Court could hear this one. The Sixth, Seventh, and Eighth Circuit all say First Amendment protection is not provided for written words on clothing. Ninth, Fourth, and Fifth say otherwise. So, you know, we'll see. As Anthony Rothert, who's the ACLU direct lawyer in St. Louis, the idea that words, I would agree with this, the idea that words written on clothing aren't protected by the First Amendment unless everyone would understand their message denies constitutional protection to one of the most common forms of public expression.
Brenda, do you think there's a counter argument to that?
Yeah, when I looked at these cases where you have words on clothing, the action that occurred, you could see was in fact related to the clothing. Either they said you can't wear that clothing or you must wear that clothing. And here, the words are just, what if you had North Face on your shirt? I mean, so I just don't buy that argument. I actually think the more interesting argument is the fact that they were standing there with other protesters. And to me, it might be the continuation, because this is a qualified immunity case, the continuation of the protest and whether it was reasonable for the police officers to think that they were dispersing this crowd that was throwing rocks and other projectiles, whether that was a continuation of that or whether it was like, no, it's sort of a peaceful gathering on the sidewalk and they're just watching what you're doing. So I find the dissent in this case interesting about as the issue for whether that should eliminate the qualified immunity.
So I'm glad you brought up this issue of qualified immunity. The ACLU is saying that they have, quote, important new historical evidence that relates to qualified immunity. Bill, this is an issue that you have been all over, the issue of qualified immunity. What do they think they found here and what impact could it have?
Well, that some of the words in I think it's the 1871 Ku Klux Klan Act that establishes the Section 1983 cause of action for people to try to vindicate their civil rights, that some of the words were left out in a codification, a recodification, sort of like bringing it, just like making sense of the way the statutes are put together. And those words that were left out are words that say basically that this right to vindicate your civil rights exists regardless of what common law said before. And the reason that that's important is that the whole concept of qualified immunity, which is a judge-of-age concept, there's nothing in statute that provides for qualified immunity, that the whole concept of is from the common law. It was Chief Justice Earl Warren who said that there should be good faith qualified immunity exception in 1983 cases, but it was based upon that he brought that from the common law. Well, what the ACLU is saying, hey, these words that were inadvertently, a scrivener's error, were inadvertently left out of this statute, specifically address the fact that the common law doesn't apply to vindicating these civil rights. Do I think the Supreme Court's going to buy that? I don't really. But
I was just going to ask you that. Eric, do you think the Supreme Court's going to buy that?
No, that's a stretch. They're saying that something was done incorrectly in 1871, and now 100+ years later, we're just figuring it out, and we want to go back and correct it. That's not going to fly.
Hey, we're originalists.
Yeah,
we
right.
want to know what they thought then.
Oh, the sarcasm in this room, it hangs thickly. Brenda, this issue of qualified immunity, we have talked about this a lot on this legal roundtable because it seems to be shifting. Just how much leeway do we give people because they're doing things in the course of their jobs, I guess might be a way to summarize it. Do you think the Supreme Court is ripe to revisit those kind of questions?
Well, correct me if I'm wrong, Bill. I believe there's a division in the circuits on this because some say you have to have a clearly identifiable constitutional rights that the officers would know about, and then they engage in conduct that removes the qualified immunity. Other circuits, I think it's the Ninth, maybe one of them, where it just has to be something that you'd recognize, and it doesn't have to be clearly identified. And and I should add, when I say clearly identified, what they mean by that is a court has said this is a protected constitutional right.
So that might be something. If there is a split, it might be time for the Supreme Court to look at this. However, they might not go the direction Bill Freivogel wants them to go. I don't know. It's a roll of the dice here. We are talking today to our legal roundtable. That is Brenda Talent. We're also talking to Bill Freivogel and Eric Banks. Coming up next, we're going to talk about a $745 million verdict against the manufacturer of whippets. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.
Welcome back. A St. Louis jury returned a $745 million verdict against the manufacturer of Whippets this past month. Now, this case involved a young woman's tragic death. And the biggest part of the verdict was not against the man who plowed his car into her and her place of employment, but the company whose product he used to get high. And these are these nitrous oxide gas canisters. Eric, are you surprised to see that the lion's share of this verdict, $700 million in punitive damages, this is against not the driver of the car, but a company called United Brands?
Well, they call them punitive damages for a reason, and it was certainly the intention of the jury to punish the manufacturer. And based on my knowledge of the case, I think it was a well-placed punishment. But I don't think it's going to stand. I believe that a jury verdict is just another step in the settlement process. And I think that the plaintiff's attorney and the defense attorney and their respective clients need to get together and settle for the maximum caps of that the state of Missouri would allow.
And the maximum cap, that's going to be lower than $700 million. Yeah. So this jury came in just hot. They were not happy about this conduct. It was interesting. The lawyers told jurors in this trial that the company had stopped selling the product in smoke shops the year before, or the year of this tragic death. Well, they came back from the weekend and put out on a folding table a full roster of all the products they had been able to buy over the weekend at smoke shops. You can see how a jury might get a little angry about this.
Yeah, that's pretty tangible evidence of that they were still doing it.
So what's the moral of the story there, Eric, as a juror or a lawyer who's sometimes in front of juries? I mean, you can't go saying things like that knowing the other side has a weekend to go shopping.
Well, that's certainly true, but you're not supposed to say anything that you know is not true anyway. So shame on the defense attorney for that.
So in this case, this thing was apparently going so badly, or maybe it was pure coincidence, that the company literally filed for bankruptcy in the middle of this trial. Brenda, you know a lot about tax law. Is that going to help them?
I actually, for the timing, I don't know the answer, but I do know this. In bankruptcy, you typically cannot discharge punitive damages if it was in fact because of willfulness or maliciousness. I believe that's the standard in the bankruptcy law. So while you might be able to discharge some judgments, the punitive ones you may not be able to. And I think the question here is whether you would say this was had a finding. I know they had a finding of willful disregard. Whether that also meets the conjunction and malicious or not. I mean, it does. They certainly ignored a lot of evidence as they pursued their marketing strategy. And I don't know on the timing. I'm not familiar enough with bankruptcy law if the timing of their filing somehow helps them because the judgment came after their filing.
Yeah, that was interesting. I mean, you have to think, like, what is going through these lawyers' heads as they're sitting in court that at some point somebody's like, yeah, I think we need to go for bankruptcy. I've also been struck by just how many really big verdicts seem to be coming out of St. Louis City and St. Louis County lately. Do you think these are just catching my attention, or is this now becoming a place where people know that they can come and they can get a jury that's going to really want to stick it to the man?
Well, the city of St. Louis has always enjoyed that reputation. I think that the fact that it's developing in St. Louis County is what's really newsworthy. But I cut my teeth on railroad defense litigation, and there was before the forum nonconvenience laws were changed, you literally get a pen and just draw a circle 300 miles within the city of St. Louis. And so lawsuits were attracted to the city of St. Louis from, of course, Missouri, but also Illinois, Tennessee, Arkansas, Oklahoma, Iowa, and maybe a couple other states, because they were all within 300 miles within the city limits. Now, the law has changed, and it's not as favorable to plaintiffs as it used to be, but I am not surprised by this verdict occurring in the city of St. Louis.
But you're saying you're seeing a lot of big verdicts come out of the county as
Yes.
well. I think you're right about that. That's more of a change.
As far as I'm concerned, that's the when a dog bites a man, it's not news. When a man bites a dog, it's news. That is the news, the way that the verdicts are coming down in St. Louis County.
Brenda, that is interesting to me because we are in a state that I think has tried to pass some laws to get a handle on these giant sorts of verdicts. We want this maybe to be more of a pro-business climate here in Missouri, and yet we have some runaway juries, perhaps.
Well, that's the beauty of having jury trials, right?
Right. You don't have to listen to the state legislators when you're there deliberating, right?
That's right. And
Okay.
the legislature is going to get the last word in terms of the punitive damages cap.
Yeah.
So jury verdicts are always newsworthy. Appellate decisions are not. So just because you win the verdict doesn't mean you're going to be able to keep the verdict, which is why everybody needs to settle.
So when we're talking $745 million, is this something where you think this company could get away with settling this for like $10 million?
Unless I would think that they would be able to settle it for a whole lot less than $10 million.
Whoa. So these eye-catching verdicts may mean very little.
Well, it's a nice psychological win. I mean, it helps the plaintiff's point of view in terms of settlement negotiations by having this jury verdict out there.
Yeah. Well, we do have to say Simon Law Firm, they're the ones who had this victory here. They have scored some big victories lately. That's a firm I'm keeping an eye on. Now, we promised we'd get to the big legal questions. And so here is one. Who owns the phrase first alert weather? That's very important. I don't even know if I'm allowed to say those words on the air. They appear to be trademarked by another media organization. I'm joking about that. I can say those words on the air. The parent company of KMOV filed a lawsuit in federal court claiming that KSDK stole the phrase from them. They point out that Gray Media Group, that owns KMOV, says the stations they own began using this phrase in 2005. They registered it as a trademark in 2007, began rolling it out in the St. Louis market in 2022. Later that year, they say KSDK started putting that alert on their graphics. Are these some dirty trademark thieves, Brenda?
Well, the court will decide that. I mean, one of the things about trademark or copyright law is don't necessarily assume that common sense will apply. It often doesn't. But it is interesting. I mean, when you look at trademark protection, you got to show that it was valid, legally protected mark. They did. It's registered, that they own the mark, and that the use of the mark causes a likelihood of confusion, mistake, or dilution of their mark. And what is interesting is when you go into the pleading, they actually allege, whether this is true or not, they allege that they licensed the first alert weather mark in a number of different markets, including in the St. Louis market, and that KSDK decided not to renew its license for use of the mark in 2015.
So they were paying to use this phrase.
If that fact is correct, then it appears that at some point in time, KSDK treated the mark as legitimate and that they needed to pay a license for it. And the timing of this is a little strange too, you know.
It's a little strange.
But even in trademark, again, you know, there are words that because of their usage or their phraseology you can lose the protection. I don't know that first alert or first weather alert, whether that's distinctive enough or whether you look, but because actually when I saw it, I thought that's sort of a weird combination of words.
Right.
That was my reaction.
I don't even like the order it's in. It doesn't roll off the tongue. I wouldn't have trademarked that, and that's why I'm a broke radio host and not laughing all the way to the bank.
They are very generic. And you know, if you're talking about storms, one would think those words would be involved in whatever graphic you're putting up there. So.
Right. But now that I know about this, you know, they were paying for the license. They're no longer paying for the license. I feel like I want to give the people suing $745 million. I do. What do you think? Come on, jurors. Are you with me here? All right.
Well, I definitely think that KSD was trying to take advantage of the confusion that the similarities of the marks would cause, and therefore I think that they're going to be found liable.
You think KSDK could have some trouble here?
Yes.
Interesting. Well, keep your eyes peeled. See if you see First Alert Weather on your TV. They may stop using it now that these papers have been filed in court. On a more serious note, perhaps the biggest story in St. Louis in recent weeks has involved the community radio station KDHX. They've fired a dozen volunteer DJs in recent weeks. They've suspended more. One of these DJs has sued. She asked for a temporary injunction that would give her show back. Now, it's interesting to me here because she's a volunteer. She wasn't paid to do this show. A judge ended up saying, I'm not going to give you this injunction to give this back. Why do you think that was a hard road for her?
Well, I think one reason it's hard to get an injunction to get your job back, and particularly, I guess, if you're a volunteer. But in this case, I believe that it was also discovered that there was a grievance policy, and it seems as though the former DJ didn't know about it and didn't try to avail it. But yes, so I think that was one of the things I think that the judge was considering, and not issuing an
So do you
injunction.
think that, she doesn't get the injunction? Injunctions are very hard to get. Do you think this lawsuit could have a chance?
I don't know. I find that this whole dispute is very hard to follow, even though I've been reading everything and listening to everything about it, because there are all these statements about diversity, equity, and inclusion, and yet I don't hear very much in the way of examples of how anyone has violated somebody else's rights in the workplace. I would like to have a little bit of concrete information about what's going on.
Well, if the board of directors of KDHX is listening, Bill Freivogel would like more specifics. Now, a large group of KDHX associates, these are members and volunteers, they would like the board to meet with them. They want to topple some members. They want to get better representation on the board. They met the other night. They say they tried to call for a meeting using the board's policy. The board ignored them. So they had a meeting anyway, and board president Gary Pearson showed up.
I'm here to state that this meeting is not a validly called meeting of the corporation. It is not a legal meeting.
Oh, I'm sorry, you're not on point for what we're discussing. We are observing Robert's Rules of Order.
Thank you very much. Good night.
You're out of order.
Okay, good night.
So that is from a meeting of the KDHX associates, and the board president, Gary Pearson, they told him he was out of order. He did leave. Now there's this question. At this meeting, actions were taken. Was this a valid meeting? Was this not a valid meeting? Brenda, how do we begin to answer that question?
Well, we need to look at the bylaws of the corporation and see what they provide about calling meetings, removing board members, or adding board members, and whether those procedures were observed.
And so it all comes down to what is going to be in these relatively obscure documents filed by this nonprofit probably decades ago.
Right, unless the membership or donors or whatever can show that the board is not operating in alignment with the mission of the organization, at which point, again, we're talking about a lawsuit to call them into to challenge their right and how they're operating the company. So, I mean, you can say, we don't have to follow the bylaws because it requires that we go through your board, but you, board, you're not functioning in your fiduciary responsibility as board members for this corporation.
So we got a question on Twitter that kind of aligns with what you're saying there. They say, quote, the board claims to have legal control, but they seem to be negligent in their duties and have misread state nonprofit law. Plus, tanking the station during pledge drives seems like a breach of fiduciary requirements, right? Well, when it's put that way, it does seem like they'd have a pretty good case.
Yeah, when it's put that way.
So, Eric, do you think there is a chance that they could push this, that there could be a lawsuit that would say, hey, this board has violated its fiduciary duty. We, the people, are going to take over?
I don't see it happening. Boards have a phenomenal amount of discretion. And I'm mixing my metaphors, so let me use a employment law metaphor. The United States Supreme Court has said businesses have the right to make stupid decisions, but you cannot make a stupid decision because of somebody's protected class status. Well, I think the same thing would apply in this nonprofit arena. Boards have the ability to make stupid decisions, but they cannot violate their fiduciary obligation with that stupid decision. But no court is going to second guess. The board decides to go left and other folks want them to go right. I mean, that's the board's. And the remedy is to vote the board out of our office.
So in our final minute here, Bill, Eric's saying no court will do this. Has there ever been a court that said, hey, nonprofit, you're doing such a bad job running this nonprofit, we're taking it away?
I just say first that when you're a Pearson and you get yourself in the position saying what he said at that meeting, you've just about lost the argument. But to answer your question, I'm just the only thing I'm really aware of in this area is because my wife belongs to the St. Louis Rowing Club, and Al Watkins, a very energetic.
A loquacious attorney.
Loquacious and litigious attorney. At one point, challenged the bylaws of the St. Louis Rowing Club and the actions of the board in implementing them. And the board had to make a lot of changes to the way that they did things.
So maybe KDHX should hire Al Watkins. This may be.
Don't take me.
We can make this situation even crazier. Bill Freivogel, I want to thank you so much for joining us today.
Thank you.
And Eric Banks of Banks Law, thank you so much.
It was a pleasure. Thank you.
And Brenda Talent, CEO of the Show Me Institute, thank you for joining us.
Thank you for having me.
This episode was produced by Sarah Fensky and Alex Hoyer.
Audio engineering and podcast design by Aaron Dorr.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
St. Louis on the Air proudly supports local artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, saluting Earth Day on April 22nd with an ongoing commitment to help offset carbon emissions with sustainable harvesting of Missouri forests. Details at choosewood.com.